whole city has seen the video. 9 seconds through a pawn shop window. A man in a hood empties the register. On his way out, he throws a customer into the shelves. Nobody sees his face. The hood never comes off. But the man on the floor gets up, and this city knows him. He has coached its team for 19 years. Half the city played for him. By noon, the police have a name, because one thing on that video wasn't hidden: a tattooed forearm. Today, that man sits next to you, handcuffed. You are his lawyer. Your phone is full of one question: how do you defend him? Hold that question. It has a better answer than you think. Start with why he gets a lawyer at all. 1961, Florida. A drifter named Clarence Gideon is charged with burglary. No money for an attorney, and the judge refuses to appoint one. So Gideon defends himself. He loses. 5 years. From his prison cell, he writes a petition to the Supreme Court by hand. And he wins. 9 justices, 1 voice. A poor man on trial without a lawyer cannot get a fair trial. The case is Gideon versus Wainwright, the ruling that made every state appoint a lawyer for people facing felony charges who cannot afford one. At his retrial, a defense lawyer exposed what the first trial missed. The state's star witness fell apart. The jury deliberated about an hour. Not guilty. Same man, same charge. This time, a lawyer. The man from the video cannot afford one either, so the court appoints him a public defender. You don't choose your clients. The Constitution chooses for you. First meeting. He leans back before you say a word.
I did it. Obviously. So, what's the plan, counselor?
So what happens if you tell your lawyer you are guilty? For a crime already done? Nothing. Nobody gets called. That conversation is protected. Attorney-client privilege. A confession about the past stays in the room. But ask a lawyer to help plan or continue a new crime, and that protection can fall away. But his confession does draw you one hard line. You cannot knowingly help him tell a false story under oath. No coached, I didn't do it. Ethics scholars call the collision of duties behind that line the perjury trilemma. Here is what you can do. Make the state prove it. Test every piece of their case. Because you are not defending what he did. You are defending how they prove it. Discovery lands on your desk. The state has 3 things: the video, an eyewitness, and a search. The video first. 9 seconds, phone camera, through glass. Hood up, glare on the window. A jury would see a man, not necessarily your man. Then the eyewitness. At the preliminary hearing, she points at your client, 100% sure. On cross-examination, you ask 3 questions. How far away were you? 40 feet. For how long? 2 seconds. And what did the police show you afterward? 1 photo. Only his. That does not erase her identification by itself. It gives you one more reason to test it, because certainty in court is not the same as reliability. Remember Gideon's star witness. Cross-examination exposed what the first trial missed. Then the search. 2 detectives walked into his apartment and carried out a jacket and the register cash. No warrant. For a home, a warrant is the default. Without one, or a valid exception, the prosecution can lose what the search produced. The hearing ends. Your client is held for trial, and you file a motion to suppress evidence at a separate pretrial hearing. Evidence that grows from an illegal entry can be tainted too. Lawyers call it the fruit of the poisonous tree.
The search was warrantless. No exception applies. The evidence is excluded.
The state's case just lost its spine. And you didn't trick anyone. They broke the rule. Now your phone rings. The prosecutor. You know the office. They just won a guilty verdict against a dirty cop. She is not the villain here. She is doing her job, and her job just got harder. This is how nearly every conviction in this country actually happens. Not with a jury verdict, with a guilty plea, at a table, a plea bargain. Here, it means your client pleads guilty to robbery 2, and in exchange, the state agrees to a 3-year term, subject to the judge's approval.
Robbery 2, middle term, 3 years. He enters the plea in open court. Offers good today.
Nearly 98% of convictions nationwide come from guilty pleas, not trials. The courtroom battle is the exception. The table is the system. You bring the offer to your client, he takes it. In open court, he enters the plea himself, and the judge checks 2 things: that it is voluntary and that the facts support it. No grin this time. Outside, the city is furious. He walked into that shop. Everyone knows it. And his lawyer got the evidence thrown out on a technicality. Time to take that word apart. How can a lawyer defend someone who is guilty? Like this. That technicality is the 4th Amendment. The rule that says the government cannot walk into your home, any home in America, without a warrant or a valid exception. It protects you by protecting him. There is no version of that rule that only covers the innocent. And the myth of criminals walking free on technicalities? One classic study, 1983, 7,500 cases, 3 states. Cases actually lost to those rules? Fewer than 6 in every 1,000. Not the system's backdoor, a smoke alarm. When the government crosses a constitutional line, what it grabbed can be taken off the table. Your mentor, the lawyer who freed Andre Mills, an innocent man, puts it in one sentence.
Last month, an innocent man. Today, a guilty one. The rules don't know the difference. That's the point.
3 years on a guilty plea with not one piece of the illegal search in the record. Nobody thanks you. Defense attorneys do not get parades. But look at what the file says now. The confession stayed sealed. Nobody lied under oath. The illegal search cost the state its shortcut, not its case. And a guilty man is doing honest time under a rule that will protect an innocent man tomorrow. You were never his friend. You are the system's quality control. The system didn't fail. It got tested. What happens when you tell your lawyer you are guilty? Now, you know what you tell your lawyer about the past is protected, and the state still has to build its case lawfully or offer a deal worth taking. Next case, the trial is over. The verdict is guilty. The sentence is yours.